So I see 40 participants now on the panel. So I think that maybe one or two new joiners will join us a little bit later. So good morning, everyone. For those who don't know me, my name is Monika Slomska. I'm the president of HOA and in private managing director of Knowledge Pyramid KFT. So today, our pleasure is to welcome Dr. Gábor Fodor, our expert on labor law. So today's panel is about various topics related to labor law and actualities. I think it is worth talk about. And before actually handing over to Gábor, I would like to ask everyone to mute their microphones, and please be aware that this session will be recorded. So if you do not wish to show your face on the camera, please feel free to switch off. And with that, I would like to hand over to Dr. Gábor Fodor. Please go ahead.
Thank you, Monika. So good morning, everybody. My first slide is about the language of this presentation. I understand that there are. Do you see it right?
Please share your screen.
Oh, sorry.
Yeah.
It's a bit. It shows I'm sharing. I don't fully understand.
I can see.
Yes, I can see it.
Yeah.
I can see it.
Okay.
Yes.
Okay. All right. Okay. So now everybody, please, if anyone doesn't see my screen, just write it in the chat. So let us know. So about the language of this presentation. I will speak in English because there are non-Hungarian speakers among us. But I have to apologize. The text of the law will be in Hungarian because I think it would lead to misunderstandings if I would just translate it. Just a quick example. Everyone has an issue translating the Hungarian word munkaidőkeret. I think the correct translation under EU law would be something like reference period, but if I would say reference period, nobody would understand what I'm talking about. They usually use a mirror translation called, I don't know, working time frame or something like this. So this is, I thought that maybe it's better to use the original Hungarian text when we talk about legal expressions and legal texts. But of course, I will also tell in English what it's all about.
Can everyone, sorry, my apologies. Can everyone see Gábor's screen?
Yes.
Yes, we can.
Right.
Yes,
Okay.
yes. Please feel free to raise your question in the chat box, and we will be monitoring those and obviously raise those questions whenever applicable. Sorry, please go ahead.
Oh, thank you. So this is what I intend to talk about in this presentation. But of course, at the end, we will have about 10-15 minutes for questions. So if you have questions related to other labor law topics, please feel free then to ask. So I will talk about telework and the debate whether there is such a thing as home office or not, and if yes, what is it? Then electronic legal notices, very recent and very popular issue, vaccination ID. And also I give you an update on the latest news of the rest period issues regarding last year's Constitutional Court decision. Wait, I think, yes. The first issue is, and there's a hot debate going on among labor lawyers on this issue, whether there is such a thing called home office. And a slight majority of the labor lawyers say yes, there is, and they wrote articles, what is the difference between home office and telework? And the slight minority, including me, criticize this approach and say that these legal arguments are not really convincing regarding the existence of home office. And there's also a third issue that the practice of home office at multinational companies does not even comply with the approach of those labor lawyers who do think that there is such a thing as a home office. And this might lead to legal issues later on. So this is what I would like to talk about first. The first question to examine here, because this is the only legal background we have, is the provisions on telework, so távmunka in Hungarian. And you see, I copied the text of the labor code, article 196 and 197 here. The definition of telework is, it is done at a place non-identical with the premises of the employer and made by electronic equipment, and also the result of such work is forwarded in an electronic means. This is the definition of telework and the Hungarian labor code. And you also see that there should be an agreement on telework in the work contract. I would leave these provisions out, they are not so important, but this one, for example, is important, that teleworkers should also have the right to enter the premises of the employer and to keep contact with other employees. And this one here is also important. There is a slight difference between general rules of the right to give orders of the employer and the telework rules. It says that unless agreed differently, it only relates to the tasks to be done by the employee. And as you see in this last provision, the schedule of work is unrestricted, so kötetlen munkarend in Hungarian. But quite frankly, it's this this subsection 1 of 197 is not really different from a general rule. Maybe the other main other way to give orders to the employee is to schedule working time, but again, it can be different in other unrestricted, so kötetlen munkarend, other unrestricted work schedule too. So this does not really help. So I think this is the main definition element of telework, which just saying that it's done at a place different than the premises of the employer, and it's done mainly by computer, just to simplify it. The first question regarding to telework, and there's also some debate regarding to it, if there can be part-time telework. Of course, sorry, I'm a bit misunderstandable here. I don't mean that if a teleworker can work 4 hours a day or something like that. I mean that a teleworker can work partly in the office and partly at home and on the basis of telework. And I think the definite answer for this is yes. The labor code does not prohibits this. So and actually, if you remember, there is even a provision in the text that the teleworker should have the right to enter the employer's premises. There are different opinions on this. One or two better known labor lawyers have a different opinion, but quite frankly, I think they are wrong. Nothing prohibits such an arrangement that the employee works partly on telework and partly at the premises of the employer.
Gábor, we received the first question in regards to this particular paragraph. If
yes,
it is sufficient to ask. There is a question: if someone is working in shifts, example is a service desk agent, those cannot be in kötetlen munkarend. So how this can be understood, given the kötetlen munkarend is very restricted for specific type of roles?
Yes, as you see, I have to go back to the text of the law. This last paragraph says that unless otherwise agreed, the schedule of the worker of the teleworker is unrestricted, so kötetlen, which means there can be an agreement to the contrary. So the labor code does not prohibit ordinary schedule. As we say, it's not really professional, but kötött munkarend, we can say this also for teleworkers. Nothing prohibits it. Only you have to agree thereon in the work contract. Okay, now let's go and let's see what are the arguments that there is such a thing as home office and it differs from telework. Nobody argues that there is no legal definition for it. At least I have to say, not in the business law, so not in the labor code of Hungary. For state employees, there is a definition, but quite frankly, it's pretty much useless. Scientifically, it cannot be really regarded as a definition, and you cannot find out what is the difference between home office and telework based on that law. But it doesn't really matter because that legal text does not apply to the business sector. So here are the definitions, what I call them home offices say. It's an atypical way of employment, differing from general rules for the benefit of employee. It's very important that they always say this, that this is for the benefit of the employee. Allows the employee to partly decide on the place of work. This is also a very important argument on their side. It's not regular, and I think this is of highest importance, not regular. No legal requirement to perform computer work. General rules on giving orders and working time schedule, as we discussed previously. No need to amend the work contract, and can be ordered unilaterally for 44. Well, it's not very precise, it's working days. It should write working days, not days. So these are the arguments. If you look at the articles on home office or listen to a presentation of home office, this is what they usually say. I read at least 5 or 10 articles on home office. And here is the critic of such an approach. Differing from general rules for the benefit of employee, where quite frankly, it is very relative. Like imagine a family of 5 living in a flat of 2 rooms. It's hard to argue that this is beneficial for the employee, and especially for the family members. If you also look at this, that it's absolutely good for them to work from home. For some, yes. For some employees, they really prefer to work from home, but it really it's very subjective. Some employees are in a life situation where they just do not wish to or cannot even do so. And nevertheless, it's more important from a legal or scientific point of view. I don't think this is a differentia specifica in comparison to telework. The second one, there's a lack of logic in the above arguments, because you see, they say that this is for the benefit of the employee, but also say that it can be ordered unilaterally. Quite frankly, for me, it does not make much sense. Why would it be the benefit of the employee if the employer has to order it unilaterally for 44 days? Now let's go to the second argument. Allows the employee to partly decide on the place of work. Again, there is no differentia specifica between home office and telework. This can be also said on Telework too. As I said, there's nothing prohibits the parties to agree on the Telework agreement. Now, this is the most important one, not regular. Quite frankly, for me, this argument does not mean anything. What does it mean, not regular? What is regular? They argue that like 1 or 2 days a week is not regular, but quite frankly, why not? If somebody is working from home on Mondays and Tuesdays, all weeks of the year, and then 3 days they work from the office, why would not this be regular? This does not make sense for me, this argument. And especially worrisome from this perspective for the companies is the actual practice of home office, where we all know that people working in home office, especially now during the pandemic, work 5 days a week from home. So even from this home office approach, it does not seem that somebody who is working 5 days a week from home would qualify as home office. Because even in their approach, this should be not regular. This is what they write in their articles. And of course, 5 days a week, or 5 working days a week is obviously regular, but I think even 1 or 2 days every working week of the year would be regular. The next argument is that there is no legal requirement to perform computer work. Quite frankly, just among us, I think this argument is a joke. I mean, please show me one person working from home office and not working from computer. So I cannot even take this seriously. That there is no legal requirement. Still, in practice, everybody is working from computer and home office.
We received another question in this particular paragraph.
Mm-hmm.
Is there any restriction related to the country or the place of home office/telework? Example, what if an employee would like to work from Croatia during summertime?
Yes, very good question. Actually, I did not put this in the slides, but this comes up. So what if I finish this, going through these slides on home office, and then I answer this question, okay? Because I think it probably fits there more. So let's continue this. The general rules on give orders and working time schedule. We just talked about this. This is no differentia specifica. Such agreements can be also made in Telework. And no need to amend the work contract. As I wrote, this is not even a definition element. Plus, it's very important that de facto amendments of work contract also exist in the labor law practice. So it just if the parties agree orally or even by their acts that the work contract is amended, this will be deemed by the courts as a work contract amendment, even if there is an obligation to put everything in writing. And there's also, don't forget this, and now I partly answer also already this question, there might be work permit issues too. So if the work permit of the third country employee says that he or she should work only, sorry, somebody hasn't muted the, okay, now it's okay, thank you. So if the work permit of the third country employee says that he or she may only perform work from the premises of the employer, sorry, then this might be problematic from this point of view too. And then this is also, I heard that the home office can be ordered unilaterally for 44 days. And I think that this is the most problematic one. firstly, as I refer to what I said, if it can be unilaterally ordered, then why would it be for the benefit of the employee? Secondly, this is not a definition element at all. Thirdly, quite frankly, I really doubt that this can be done. Imagine again that the home of the employee is where she lives his or her private life, and even more importantly, this might be the home for his or her family, including children, husband, wife, whatever. And I really doubt that without the agreement of the employee, the employer might just unilaterally decide that the work can be done from the home of the employee. And there's also, other than this constitutional concern, there are also labor safety issues, labor law issues, also data protection issues. I meet this all the time. How can you protect data of the employer, data of your coworkers, data of the clients, and so on, if there are other people hearing you all the time? It's not possible. So there are a lot of legal issues with this, and I really have serious doubts that an employer might just unilaterally order such a work. And as I said, with the same logic, the employer might even order office work at a restaurant without the approval of the restaurant owner. From a legal point of view, it's totally the same. I do not think that without the employee's consent, this would constitutionally work. And therefore, in my opinion, and quite a lot of labor lawyers agree with me, there is no such a thing as home office. We should use the provisions on telework. As I said, it's a minority opinion, but I do think it's the rightful opinion. And even if there is a home office policy at the company, quite a lot of clients of mine have it. I always try to make it quite similar to the telework rules because of the above concern. And as I said, even from this home officist approach, the actual practice that home office workers work from home 5 working days a week for long months now, this would not even be qualified as home office from this approach. And this is, I think, the most important message here. This is obviously, even from this home officist approach, this would qualify as telework, because they always say that home office is something not regular. And now sorry, I finished this. Very important to check the work permit of the home office employee. And also there are labor safety issues, and I will talk about that later on, but one argument on home office that the employer does not have to check the labor safety issues at the employee's home, but quite frankly, it's again a very weak argument, and I don't think it's a rightful argument. Now let's answer the question which was raised.
So there are 2 questions. So once again, the first one: is there any restriction related to the country of the place of home? So example, if someone would like to work from Croatia during summertime, what happens?
Yes, I do not recommend this for several reasons. The first reason is what I was already talking about. If this employee is a third country employee, and I actually even met this case that the employee is from somewhere from South America and went home and worked there. There are a lot of issues with this. The work permit is usually for a specific place within Hungary. So most of the cases it even contains the address where the employee should work. So if you differ from it, this might be very problematic even within Hungary. Then, if the employee works from a another country, it's regardless from within the EU or outside the EU, there might be a lot of issues. For example, there might be issues regarding the rules on posting of workers. You know, there's a European Union directive on posting of workers, which generally says that the local wage has to be paid and some other local labor law provisions has to be respected. And more importantly, there's a reporting obligation. So if your employer works from Croatia, then it's highly likely that based on Croatian law, this performance of work has to be reported to the Croatian authorities. And if you fail to do so, you will be subject to pretty high fines. I don't know about Croatia, but in Germany, this can be several thousands of euros. And in Spain, this is even irrational. It was like 187,000 euros per worker, imagine, if you fail to do such a report. Furthermore, there might be also tax law issues because performance of work is done in such country. You might also have to report your activity as a company from a tax law or from an administration law point of view. Of course, this is all subject to the local law. And then there might be social security issues and so on and so on. So what I would advise, and this is what I advise to my clients, is even for European Union workers, they should restrict home office within the boundaries of Hungary. Otherwise, this would be a pretty pretty big administrative nightmare. If you just cannot do anything but let the employee work from Croatia, South America, wherever, at least as a minimum consult to a local lawyer, so Croatian lawyer, Argentinian lawyer, whatever. Okay, and then I think I answered this question, yes.
Yeah. The next question would be what are the risks of applying home office, in your opinion, especially in the current environment? How material are these risks?
We should also think about the future when the pandemic is gone. I can imagine cases where the employee will not want to return to the office and would argue that there's an amendment of contract between the parties that now the new place of work is the employee's home. This is the first issue. The second, some of the issues I already mentioned, for example, with work permit, which might also come up later on. Actually, what I would, and also because this approach of home office is pretty much unfounded or shallow, as Professor Attila Kun wrote in one of his articles, agreeing with me. It can be an issue that some authority later on will deem this as telework and will request telework agreements and so on. So it's hard to tell, but especially for third country employees, I would be very cautious with home office, and also respecting to order home office unilaterally. This would really lead to risks, and we have not even talked about the cost and the liability of the employer issues. I think if there are no more questions, I can conclude. I can go there. Yeah,
there is one more.
Okay.
With an HOA agreement, the home office agreement, the location of work is restricted. So The assumption is that the employee cannot determine where he/she will work. So example, if the office is first location, they are obligated to return when the employer provides the policy with regarding to this. Is this correct?
I think generally, if there is an agreement that there will be two places of work, the, let's say, home of the employee and the premises of the employer, and then it's up to the employer to decide where the employee should work, it's absolutely fine. Based on even based on general labor law issues, labor law regulations. So this is what I would propose. I'm only saying that if we apply home office, I would be on the cautious side and would make it as similar to the telework rules as possible, because we simply cannot know what the court cases will be, what the court practice will be with respect to so-called home office. And again, these arguments that there is such a thing as home office do not seem to be right or convincing at all. So this is my concern. But if you make it as similar to telework rules as possible, and there is an agreement there on, the employee agrees there to, I do not see any issues that at some point the employer decides where to work. Only make it very clear in a policy or in an agreement or whatever it is that there is such a right for the employer.
Thank you, Gábor. We can move ahead.
Okay. So it also comes up recently. What happens if there's an accident in home office? I read some of the opinions that it is what I call geography based, that there is that only accidents happening in the room where the employee works might cause the liability of the employer. But quite frankly, I don't think this is such simple. Because it's not even in line with the text of the law. So I think what really matters is the connection with the employment. So if the employee usually works from a certain room, but he or she goes out to the garden with the laptop in his or her nap, and then, I don't know, suffers some damage from the laptop, some electrical issue, whatever, then this might be the liability of the employer too. So I would not connect it to some geographic area. Rather, I would check what can be causes of damages which might be in connection with the employment. And also, what I see quite often is that the equipment what the employee has at home is not as good as she or he would have at the workplace. For example, the monitors are smaller, and there might be issues with the sight, or there might be back pains and so on. I quite often meet these issues, and this is what I'm saying, that even though there's a law now that even for telework, which is in effect until May something, if I remember it correctly, that the employer does not have an obligation to check the work environment. This does not mean that the employer would not be liable. It's only an administrative issue that it's sufficient to give information on work safety to the employee, but it does not mean that if some accidents happen or some health issues take place, that the employer would not be liable. So I would be, I would not stop caring about health and safety issues in home office. And there's also another issue regarding costs. Quite frankly, even home offices, most of them are of the opinion that costs of the employee with respect to home office should be borne. So if there's an extra heating or extra electricity cost and so on, this should be borne by the employer. Nevertheless, what I see in practice is that quite some employers do not want to pay for this. And I even read an argument that since home office is beneficial for the employee, it has a consequence that such costs are not to be borne by the employer. But again, there are even two issues with this short argument. The first one is that it's very debatable whether home office is beneficial for the employee, as I said. And even so, if we accept this argument that it is beneficial, nothing in the labor code says that rightful costs of the employee should not be reimbursed by the employer. So I think the rightful interpretation of law is that costs should be borne. But again, I read arguments to the contrary. And well, I don't know when the pandemic will end. Of course, nobody knows, not even doctors. I even read numbers like 2023, which is like 2 years ahead from now. So it's we don't know when this will end, but hopefully sooner or later the pandemic will end. And at least latest at this point, if not until then, all these issues which I was talking about should be handled. We don't know, but we can guess that there will be quite some employees who will not want to return to the premises of the company, because as I said, the group of the employees really started to like to work from home office. And therefore, all these issues which I was talking about with respect to home office, I think they will be permanent. They should be somehow handled. And all these problems, all these issues I was talking about should be handled by the company. And I think you should start to think about it now. And I think there's it's pretty important to know that I talked to the guys who are writing the labor code, and until at least the election of 2022, no essential legislation is to be expected. They are among us pretty much afraid of changing anything in this political situation. So we have to leave from the text of the law as what we have for now. And quite frankly, I'm not very happy about this, because there are some serious issues with the present text of the law, but we have to live with this. So no legislation is to be expected until at least 2022, so next year. Now, let's talk about the opposite case, which I also met, that there are employees who are so afraid of COVID that they simply do not want to work at the office. And what to do with this? First of all, I think it's very important to check all documents available, work contract, home office policy, whatever there is. What is the legal situation, where this employee is obliged to, what are his or her rights are with respect to this. And then there should be a risk assessment made on this. There might be employees who have a very serious health condition, and also there might be issues that the work conditions are such that they are very close to other employees who sometimes don't wear a mask, and so on, which we know that we could do something about, but we know real life. In this case, in this very exceptional case, such a refusal might be deemed as lawful, but in most of the cases, unless there is some serious, really serious argument to the contrary, then refusal to work from the office is unlawful. It's simply because there is always some slight danger when you work, when you perform work. Imagine an office work, you might fall down from your chair, you might get an electric shock, whatever. And this is only office work, of course. In physical work, it can be even more dangerous. So simply, if you perform work, there is always a slight risk that your health or even your life will be damaged. So I do not think that this is a rightful, in the general cases, this is a rightful cause for the employee to refuse to work from the office. Again, in very, very exceptional cases, yes, but in most of the cases, this would qualify as a refusal of the order of the employee from a labor law point of view, which might even lead to termination of employment in at the end if nothing else works in the case of this employee.
We received a question, if you don't mind, Gábor, to this particular point, on how to define the cost to be paid by employer due to home office. So the employee works from home, from his rented flat,
Yes.
or from the weekend house. How the employer could check this?
Very good question. There's no real good answer to this. I think the best if the employer and the employee agree to this. There's even, in case of telework, there's a legal possibility on this. Otherwise, if there's no agreement, of course, the employee will have to prove this. And the employee would really have a hard time to this. So I was talking about general principles, but if you go into the details, like the employee would have to prove that before the home office times, he or she spent, I don't know, 10,000 forints on heating, and now he or she spends 20,000 forints on heating. So this extra 10,000 should be reimbursed, the same with the electric bill, and so on and so on. But it's not easy at all for the employee. So I think, and also, quite frankly, I don't think that that an employee from who is not in some bad relation with the employer would raise this, because we are talking about 10,000 forints a month or something like this, I think, most of the times. But this would be the legal answer for this. Otherwise, how could we know this? The employee will have to prove this.
I have a question related to the same topic. Sometime last year, there was an announcement from the government about potential support of around 16,000 plus half in terms of the support of the employer to the employee in regards to costs and so on. So is this still valid? If so, how this can be well interpreted?
Yes,
by
this is more a tax issue, but as far as I know, this regulation is valid or in effect until 20-something of May. So for, like, I would say 1.5 months it is, and then we don't know what is going to happen. But again, this is more a tax issue, that this was about that this amount can be paid to the employee without tax burden.
Then there is another question, if you don't mind. So given that the Hungarian government had not restricted people to go out, all employers have the right to determine office as work location. Therefore, no one has the right to refuse to come to the office. Is that correct?
Mostly yes. Mostly yes. I would refer to this slide, which is visible now. There might be very exceptional cases where the employee's life is endangered in a very serious way if he or she goes to the office. But again, of course, I'm not a doctor. I cannot assess this. I'm a lawyer. But I can imagine that there are such work environment for this employee, that he or she can prove that such work environment seriously endangers his or her health or even life. And in this case, I can imagine, for example, a seriously ill doctor who is ordered to work at the COVID hospital. I think in this case, he or she might say that, no, this is too much for me. I don't want to die because of this. But I'm talking about such serious cases. So most of the time, and I would refer to the last paragraph that I wrote here, in most cases, I don't think this is the case. And again, I would tell this employee that just because there is a slight risk of getting sick from COVID, it's not a good reason enough to refuse work. And of course, it does not mean that if the employee gets sick and he or she can prove that it was related to the employment, then the employer will not be liable. This might happen, but this does not stop workers to perform work. Again, just performing work itself includes some element of danger, even office work.
Conscious of time, I think we should move ahead.
Okay. Now another interesting topic, also very recent topic, and I also meet this that employees work in home office and employers are not in the same premises as them, and what to do with their legal notices, notice letters, work contracts amendments, and so on. And also before the pandemic, this was already a topic for years at multinational companies, how to use less paper. So I think this is in these years it's a very ongoing theme here. And now let's check, what does the law says? It's a paragraph 22 says that an electronic document has to fulfill 3 requirements in order it to be deemed as being in written. The first one is that it should be the person making the statement should be identified from it. Then the time of statement should be identified, and the information on the legal statement should be identified from the document itself. It seems to be very easy legal text, but there are pretty much debate going on in the last almost 10 years with the interpretation of this. The most important debate is whether an email qualifies as such. And some lawyers say that an email does not qualify as such because it can be falsified. You cannot be always sure that the person who is stated there as the sender of the email is the real sender. So these legal requirements do not always meet. But there's another group of lawyers who are saying that this is not really true. Generally, and most of the time, if you got an email from somebody, you can be sure that this email is from this person. You can also see when this email was sent, and you can also see the content of this email. So this legal requirement here is fulfilled. And it's interesting, there's a debate on between quite a lot of labor lawyers and quite a lot of civil lawyers. And the labor lawyers are on the more, let's say, employer-friendly side here. And the civil lawyers are on the more employee-friendly side here. Like, they are more conservative regarding what qualifies as an email. So the good news is there are some labor law judgments where emails are awarded as being in written. But there's also bad news. Exactly the same legal text as you see here, word by word the same text, has the civil code also. And there are civil law judgments which say that an email does not qualify in writing. And quite frankly, this is nonsense that the same legal text, if it's judged by labor courts, then they will say email is okay. If it's judged by civil law courts, they say it's not okay. And I'm very sure that this debate will end up at some very high level of the Supreme Court at the end. And we don't know what will be the outcome, who will who will have the stronger arguments in this. So at this moment, there is always a legal risk whether an email, a simple email, would qualify as being in written. And there's also another issue here. At quite some companies, there are now introduced what I would call electronic signature systems. So not a simple email, but there's a system of electronic signature in these softwares. And I actually met quite some issues with regarding to these signatures. The first one, it sounds pretty simple for a lawyer, but it has to be mentioned that in these electronic signatures, it's not your scanned signature what counts as signature. So it doesn't really matter that there is a signature saying it's undersigned by you is on this document or not. It doesn't matter from a legal point of view. Is this electronic sign which qualifies as electronic signature and which proves that it's your personal signature, which this electronic document should include. And in quite some cases what I met, this electronic signature is missing from these documents, or it's not convincible. It doesn't say that it was undersigned by a specific person. So this is what I would advise, that always check whether this electronic signature would qualify as your personal electronic signature. It would be clear from the document itself that it was signed by you and not by just some system, because this is what I saw in quite some cases. The good news is that these electronic signature systems can be modified or can be altered in a way that it can be acceptable and it meets this legal requirement here. So if you receive, and also I have to tell you that these systems do not even advertise themselves, if you have a closer look, as totally being in line with Hungarian law. So if you introduce these systems, it does not mean that you are totally fine. You have to work on it, include a lawyer and start to work on it, how to amend this system so that it fulfills the requirements of this paragraph 22 of the labor code. But it can be done. It can be done, definitely. Now, how to contract in these COVID times? Really, my main advice is always consult a lawyer. Don't believe anything which you hear from other providers that you have a good system and so on. Always consult to a lawyer whether your system would qualify as a system produces legal declarations being in writing. But again, as I said, this can be done, this might work. Nevertheless, never forget the above three conditions. If the above three conditions are not met, then your legal statement will not be deemed as being in written. And if you are not sure, then I'm sorry to say, rather stay on the paper-based side. only use electronic documents if you are fully sure that you fulfill the above requirements. And especially in termination, be even more cautious, even though we, as I said, we have one or two court cases which rewarded that electronic piece of information might be also being deemed as writing. There's still a huge debate going on. So always be on the safe side with this. But again, if you put quite a lot of energy in your electronic system, this can be turned in a way that it can qualify as being in writing.
We have a question regarding this topic. The question is about what about auditors? They usually ask for resignation, mutual agreement, or contract of employment, and check the signature to confirm the lawfulness of the document and the fact of establishing or ending an employment. Could the electronic version work when it comes to auditors?
Well, I'm sorry, I'm just a labor lawyer. I'm not a tax lawyer. I do not really know anything about auditing. But based on just general common sense and based on law, if the electronic signature is qualified as being in writing, based on what I have just told you about, then based on my common sense, they should accept this. Because the law says that electronic signature under the conditions I was talking about might also qualify as being in writing. So I don't think that auditors can challenge this text of the law. But they might have these issues, which I also had, that quite a lot of systems are on the first sight look as providing documents being in writing, but if you take a closer look, there are serious legal issues with them. But again, consult your lawyer, and I'm sure you will find a solution. I worked on such cases, and at the end, we also always found some safe solutions for this. Yeah, and we talk about the termination letters. Again, only if you are very sure that the electronic declaration will be deemed as being in written, use this way of termination. Otherwise, use post, whatever. And also I have some example of a questionable practice. I'm not saying it's bad because there's no court decision on this, but at least questionable, where not even the person exercising employer's right, but somebody else, in this case it was an HRBP, sent an email to the employee, and there was a scanned document to it which contained the termination. And now imagine this from a legal point of view. What is a scanned document? It's not the original paper document, it's just the scan. It's practically it's a copy of the document, and this is attached to the letter. Now imagine this to real life. You got a letter from a post letter from the HRBP, which contains a blueprint or a copy of the termination letter. Would you believe this is authentic? I don't think that this would be the case in case of paper, and this is exactly the same in electronic form. So I would be very cautious with respect to scanned documents. I would not use them. I would strictly stay at the email itself, so of the plain text email. If I would have to make an employer declaration, I would be very cautious with. I don't think it's even qualified as electronic or qualified as being in written. But again, there's a court case going on. This we'll see what the court will say on this. Now, this comes up very often, how to terminate an absent employee. So I said, I'm sorry to tell this, but still the most sure way is the paper-based termination letter, and then send it to the address of the employee. Or use electronic documents only if the before mentioned conditions are met. And there's also an issue which I meet more and more here, that before the pandemic, how did it work? We called in the employee to a meeting room, and how it worked for 15-20 years in my practice. You offered him two pieces of papers, termination or common consent agreement, and the employee choose one of them. Now, this of course does not work if the employee is not present. So this really causes problems. This really causes issues with respect to termination agreements. There are several ways. Of course, the easiest way is again to call in the employee, but then it's not so easy as before, just to call up from another room. The employee will have questions, will have thoughts, and so on. Then there's also two other ways. Of course, I didn't even write about the third way, is that you send the employee a letter and then it sends back. But I don't think it's a very safe way, because you don't know the date of the document. You cannot even be sure if the employee will sign this. So there are two, not perfect, but better than nothing ways to solve this. Is to use electronic documents, as I was talking about, if it's possible, or if not, then it would be also a solution that the employee signs one piece of paper and the employer signs another piece of paper with the same content, and this based on labor law, but also civil law rules. If you exchange these pieces of paper, this will qualify as an agreement. So again, consult to your lawyer, but some of these might work, if nothing else.
We have another question.
Yes.
To this one. Is it possible to use e-signature in all cases, example in case of employer certificate issued to bank? And can the employer decide the way signature in all cases?
Again, this is a very complicated issue, and it relates what is qualified as being in written. But if your e-signature is qualified as being in written, then the bank also should accept this, because again, this is also in the civil code. But they may argue whether a way you sign your electronic document is really to be deemed as being in writing or not. And since this is not decided yet, even though there are like this electronic signature is a possibility for almost 20 years now in Hungary, but still there are serious legal questions. What is to be deemed as electronic signature, what is not? I would consult to a bank. So there might be issues with this. Again, sorry, I'm a labor lawyer, so this what we are talking about here is more civil law or even banking law. But based on my common sense, I think the bank might raise questions whether your electronic signature really qualifies as being in written. But if you can prove there are electronic signatures which are undoubtedly based on the force of law deemed as to be in writing, this what in Hungarian called fokozott biztonságú elektronikus okiratok. It's hard to translate this into English, like high security electronic document, something like this. Then I don't think the bank will raise any questions, or if they do, then it's more their problem than your problem. But if it's not this high security signature, then there might be debates on this. Okay, now the next, and I think it's the hottest topic of all, vaccination ID. I met this question literally every day last week. How is it possible to ask the information from employees whether they are vaccinated or not, or to put it in a more legal way, whether they have the vaccination ID or not? And the good news is that if you want a black and white answer, the answer is yes, it is possible. However, there are quite some legal requirements to meet here. First, I think the most important one is that there should be an assessment of legal interests. Of course, the employer has a legal interest for labor safety, that the employer will not be liable for his or its employees getting ill from COVID at the workplace. Employer also has a legal interest that their employees stay safe and healthy. And there's also a legal interest of the employees that to their privacy, to their private information, to their, especially their health information, which is a highly qualified personal information based on data protection law. And you have to make an assessment and putting these legal interests together. And as I wrote here, in my opinion, usually it is the employer's interest which is stronger. I think it's more important to have a safe workplace, not to have to talk about liability issues, to have healthy workers, than the privacy concerns of the employee. But there might be some exceptions, especially in case of teleworkers, for example, but it's also not totally clear there. So they might also meet other people, employees, clients, and so on. So this should be assessed on a case-by-case basis. And it's very, very important that you remember that there is no data handling without such an aim. So you cannot just handle the data on vaccination ID without wanting to do something with this data, wanting to do some measures at the workplace. For example, if you can order that some employees who are not vaccinated or does not have vaccination IDs do not meet certain groups of clients, do not perform certain tasks. I even consulted a doctor on this issue yesterday on behalf of a client. You might even make measures that you make mix of workers, the mix of which results in a smaller chance of health risk. Or you can order that those who have vaccination IDs might only use paper masks, while those who do not have has to use FFP2 masks, things like this. It's a very complicated issue. A doctor definitely needs to be involved. And also from law, there are at least 4 or 5 fields of law, not only labor law, but also data protection, and then labor safety law, and then even constitutional constitution law should be deemed should be viewed here. So it's a very complex issue. But after the end of this assessment of interest, there might be some cases, and I think in most of the employers there must be such cases where you might make measures based on who has the vaccination ID and who does not have. And there's also 2 more questions. Can the lack of vaccination ID at some point of time, I think not now, but when we will have even better numbers, like 40, 50, 60% of people will be vaccinated, deemed as an unjustified absence, so igazolatlan hiányzás in Hungarian, due to the condition unfit for work, so munkára képes állapot hiánya miatt. And I think that in extreme cases, this might be the case. So if you cannot organize work otherwise, and there's a really huge interest of the employer to have employees who has the vaccination ID. I'm really telling these extreme examples like people working with COVID patients or people working with high risk group patient, like in elderly homes, whatever. And this might also come to the business sector, like you are somebody who are delivering food to elderly homes. This might also come up, that you might require that you only employ people with vaccination IDs. But again, this should be the last resort to do so. You should, before examine whether you cannot organize work in another way, so you put vaccinated employees in these high-risk jobs and you put non-vaccinated in less risky jobs. But if there's no way you can do this, there's no other way to organize work, then I think at some point you might even say that this employee who does not have the vaccination ID will be in a condition unfit for work. Again, I'm not talking about the present, I'm talking about the time 2-3 months from now, when hopefully the vaccination numbers will be very good in Hungary. And the same is good for termination of employment. So if there's really no other way to organize work, then at some point, at some extreme point, I'm emphasizing it on some extreme point, I think you can even terminate the employee's work contract, but only if there's really no other solution for the issue. And if there's no question to this, then I would go to this last theme. It's about the decision of the Constitutional Court last May. I talked about this last time when I spoke at HOA. I think it was like last summer, but I'm not sure if all of you heard this. So I talk about this shortly. It's a very sad story, and it's a not very clever decision of the Constitutional Court. It was a hospital case, and they ruled that the Hungarian constitution requires that the daily rest period and weekly rest period should be given out separately to the employee. And they constructed some argument on this, which was quite frankly not very convincing for me. I even wrote an article back then in last summer on this. But we cannot do anything about this. It's a final and binding court decision of the Constitutional Court on the interpretation of the labor code. And based on this decision, you cannot give out at the same time daily rest period and weekly rest period. Just give you an example, what does it mean? Just a normal time schedule, so 5+2, Monday to Friday working days, Saturday, Sunday rest days. If you just count with the days and do not include any extra provisions of the labor code, it means that you will have 2 rest days, Saturday and Sunday. And before Saturday starts, so before 0 o'clock on Saturday, or after Sunday stops, so after 24 hours on Sunday, somehow you have to give out 11 hours of rest period for daily rest. And what does it mean? It means that if the employee is given 11 hours of rest on Friday because there's no other way. There's another way on Monday morning, but let's talk about Friday first. That it means that the employee has to stop working at 13 o'clock on Friday, which means that if the employee is working 8 hours a day plus there's a 20 minutes lunch break, then the employee has to start 4:40 a.m. This is not very overthought, I think, what the Constitutional Court did. And it's not much better if you give out this 11 hour of daily rest on Monday, because this means that the employee cannot start before 11 a.m. on Monday. And we are not even talking about overtime on weekend or anything else. I talked about in details last summer what are the solutions from this. There are some solutions, but they are pretty much you have to pretty much change the regular work schedule in order to be in line with this. Like, for example, if your working days will be 10 hours from Monday to Thursday, then this might be good. But again, then there will be no work done on Friday, and I don't think that most of the companies would wish for it. All other solutions are like in the gray zone. There might be arguments against them. And actually, this is an issue from last summer, which is still not solved. And the bad news is this is why I wanted to talk about this, that last autumn there were talk about a possible amendment of the labor code. Even in this article, which I wrote, I proposed a possible solution, which would be in line with EU law. This would be, by the way, that instead of 2 working days, only 35 hours of weekly rest should be given out, which is totally in line with the EU law. And then over this 35 hours should be 11 hours of daily rest, and we are still not at 48 hours. But because of the reason I was talking about at the beginning of my speech, there will be nothing from this draft. There will be no legislation until at least 2022. So we will have to live with this problem, and there's a huge issue here. I know that at least one company has received 200 plus court claims with respect to this. The good news is that this is, as far as I know, a state-owned company, so it's not from the business sector, but still now there are court cases going on with respect to this. And again, there is no real solution for this. Some gray zone solutions there are. So I would advise you to prepare for yourself for this risk. Also, there's another issue here which is to be mentioned. There are quite a lot of issues with the text of the working time chapter of the labor code. It's not totally in line with the EU law, and I think it was very finely formulated. There are, quite frankly, serious issues with the EU law with respect to this chapter. And the problem is that in 2019 there was an EU court decision that with respect to vacation and rest periods, the directive is to applied directly even in the business sector. And this is something nobody really talks about, that there are huge issues with, for example, counting the vacation days in hours, as many companies do, or ordering overtime on weekends, which is also quite problematic from EU point of view, which is totally in line with Hungarian law, but less so with EU law. And since 2019, these EU laws, EU regulations has a direct effect even in the business sector. And I think you should also prepare yourself for this. I think I'm at the end of the presentation. I don't know, I don't have a watch. I don't know how much time do we have, but I'm
We have
ready
still
for
8 minutes. So if there
Okay.
are any questions from the audience, please feel free to ask. Or if there are any further questions which you may think of after digesting the panel, please feel free to send those to our email address, which I just mentioned in the chat box, so hoa@hoa.hu, and we will collect the answers from Mr. Fodor. I don't see new questions. So I think with this we can close today's forum panel. So I would like to thank everyone for being here with us today, and welcome you hopefully to the next discussion, next interesting topics coming up. And I would like to thank Gábor as well very much for this very extensive information sharing. Thank you very much.
Thank you all.
Everyone. Bye bye.
Thank you.